Hi guys! Welcome to Law Diaries Lex Comentarios. So for today's video, we are going to talk about Article 38 of the RPC. So basahin muna natin kung ano yung Article 38. Article 38, Pecuniary Liabilities, Order of Payment. In case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities, the same shall be met in the following order. Number 1, the reparation of the damage caused. Number 2, indemnification of the consequential damages. Number 3, the fine. And the number 4, the cost of proceedings. So, dito guys, sa Article 38, it talks about pecuniary liabilities. So, ano ba tong pecuniary liabilities guys? Again, na-enumerate siya under this provision, which are the reparation of the damage caused. Number 2, the indemnification of the consequential damage. Number 3 is the fine. And then number 4 is the cost of proceedings.
So, itong apat na to guys na na-enumerate under Article 38, ito yung tinutukoy nating pecuniary liabilities.
So, kailan maa-apply yung Article 38 guys? So, it is applicable in case the property of the offender should not be sufficient for the payment of all his pecuniary liabilities. The order of the payment is provided in this article. Hence, if the offender has sufficient or no property, there is no use for Article 38. So, Article 38, guys, is applicable lang siya kapag yung property ng offended parties, guys, is hindi enough para mabayaran lahat ng civil liabilities niya dun sa offended party. So, kapag kaya naman or yayamanin yung offender guys, marami siyang datong, so hindi na maa-apply itong Article 38.
Again, maa-apply lang itong Article 38 kapag walang pera or kulang yung pera or hindi sapat yung property or pera ng isang offender para mabayaran niya lahat ng indemnities niya sa offended party. So yun yun.
So this article applies only when the means or assets of the convict is not sufficient to pay or answer for the monetary or pecuniary obligation accompanying the judgment of the conviction.
So, yun na nga yung sinasabi ko, di ba?
So, if the asset of the person liable, however, is sufficient to answer for his liability, the said provision is not necessary. The same is true when the convict is insolvent. So, kapag sapat naman yung pera or property ng offender para mabayaran niya yung civil liability or damage niya dun sa offended party, so hindi na applicable itong article na ito. So, the order of payment of pecuniary liabilities in Article 38 must be observed. Diba? Itong Article 38, guys, apat siya. In order yan.
So, kapag may pera, dapat ang unang bayaran is yung number 1. Kapag meron pang extra pera, dapat ang susunod bayaran yung number 2. Kapag meron yung number 3 at yung huli yung number 4. Dapat in order, guys. Dapat hindi, siguro ito na muna yung babayaran ko, yung number 3, mamaya na yung number 1 kasi ang laki-laki ng babayarin dun. Ito muna yung unahin ko, hindi pwede.
So, dapat in order talaga. This is expressly stated in Article 38, which is the same shall be met in the following order. So, ito yung ibig sabihin ng word ng provision na to na dapat in order talaga yung pagbayad ng pecuniary liabilities kapag nagkapera or may pera na yung offender. Thus, in robbery with violence against person, A inflicted upon B serious physical injuries and took the latter's watch and ring worth 1,250. As a result of the physical injuries inflicted, B was hospitalized and was not able to attend to his work for 1 month. For hospital bills, he paid 500 pesos. For his failure to earn his salary for 1 month, he lost 300 pesos. If A, after conviction, had only property not exempt from execution worth 1,000 pesos, it shall be applied to the payment of the watch and ring which could not be returned because they are covered by the reparation of the damage caused and it is number 1 in the order of payment. The hospital bills in the amount of 500 and the salary which he failed to earn in the sum of 300 are covered by the indemnification of the consequential damages, which is only number 2 in the order of payment. So, itong illustration na to guys, kapag yung robbery guys, nagnakaw siya ng watch at saka ring, which is worth 1,250 pesos guys. Itong ninakaw niya guys would be considered as a reparation of the damage caused. Kasi ito yung result ng ginawa niyang crime. Ito yung naging resulta na damage niya. So, yun yung kailangan niyang babayaran unang-una sa lahat. So, kapag may pera na siya guys, kahit maliit lang yung pera niya or konti lang or hindi kasya, doon sa damage na yon, yung una niyang babayaran is yung value ng watch at ring na nilnakaw niya because yung mga bagay na yon would be considered as a reparation of the damage caused. Kasi yung payment na yun guys is para ma-repair yung damage na resulta ng ginawa niyang crime, which is robbery. And that is number 1 sa sequence na under Article 38. So, yun yun. Tapos, as a result sa robbery, guys, nagkaroon ng physical injury naman itong si B, which is meron siyang hospital bills na 500 pesos at nakapag-absent siya sa kanyang work, which is salary niya is 300 pesos. So, etong salary niya guys at yung hospital bills, ito naman yung indemnification of the consequential damages. Indemnification of the consequential damages. Consequential damages, kung ano yung mga damage na sumunod. Hindi siya main damage kasi yung main damage guys is yung nawala na ring at watch, diba?
Yung consequential guys is parang kung ano yung susunod na damage sa main damage. Parang naintindihan niyo ba? Parang consequence ba? Yung consequence na damage na na-cause ng robbery, which is yung hospital bills niya at yung hindi siya nakapagtrabaho. So yung 500 at saka yung 300 pesos guys, yun yung susunod na babayaran ng robber. Yun yun.
Courts cannot disregard the order of payment. When the respondent judge permitted the accused to pay the 500 fine ahead and postponed the payment of the indemnity of 1,900 to some other date, he obviously deviated from the express mandates of the law. Indemnity is number 2 and fine is number 3 in the order of payment. What was done exactly the opposite of what the law ordained. What the court should have done was to commit the accused to jail for a period not exceeding 6 months. Article 39, paragraph 2, upon the non-payment of the date scheduled for its execution of the indemnity imposed by the sentence. This is cited in the case of Domalaon versus Yambao. So, yung court, guys, hindi niya dapat i-disregard yung sequence ng pecuniary liabilities. So, kung una yung reparation of damage, guys, yun dapat yung unang babayaran. Hindi ibig sabihin na kapag maliit lang yung pera ng offender, guys, at swak na swak itong pagbayad ng fine, iuunahin na yung pagbayad ng fines instead sa reparation. So, dapat talaga sequence yung pagbayad in accordance sa Article 38. There is reparation in the crime of rape when the dress of a woman was torn. In a case where the accused was convicted of rape, that part of the judgment ordering the defendant to pay the value of the woman's torn garments is reparation for the damage caused to her property and is distinct from indemnity. This is cited in the case of US versus Yambao.
So kapag na-rape yung isang woman guys, yung clothes niya na kapag nasira dahil sa rape na naganap, it would be considered as a reparation for damage caused kasi damage yun na na-cause sa rape, diba? At kailangan bayaran yun ng offender at magkaiba yun dun sa indemnity na babayaran pa niya.
Liability of conjugal partnership assets. Fines and indemnities imposed upon either husband or wife may be enforced against the partnership assets after the responsibilities enumerated in Article 161 of the Civil Code have been covered. If the spouse who is bound should have no exclusive property, or if it should be insufficient, which presupposes that the conjugal partnership is still existing. This is cited in the case of People versus Lagrimas.
Ito naman guys, ito yung case in case may liability sa conjugal partnership assets.
So I think dito na magtatapos yung discussion natin guys. Again, this is Article 38, Pecuniary Liabilities. I hope you learned something guys. If you do, don't forget to like this video and subscribe to my channel. Bye-bye!
Bye-bye!